Welcome, everybody. We're currently 26, 27 participants. We will wait another 2 minutes before starting the webinar. Okay, I think we can get started. So good afternoon again. It is my pleasure to welcome everybody to this AIPPI Swiss Group webinar about study questions and resolutions to 2024. We have so far 28 participants. So my name is Thomas Widmer. I'm an attorney at law specialized in intellectual property. I work in La Live here in Geneva, and I am a member of the board of AIPPI Switzerland. I will have the pleasure of moderating this webinar today, organized by AIPPI Switzerland with the support of AIPPI International about these study questions and resolutions 2024. So for those who are not familiar with AIPPI, just a few words. AIPPI stands for International Association for the Protection of Intellectual Property. AIPPI is the world's leading nonprofit association dedicated to the development and improvement of laws for the protection of IP. It is a Swiss-based association with over 8,000 members worldwide. The AIPPI World Congress was held in Hangzhou, close to Shanghai in China, last month. And 4 resolutions have been adopted. So this is the subject of today's webinar. These resolutions this year, as always, these resolutions will be sent to WIPO, to WTO, and to the patent and trademark offices around the world. The objective being to develop international IP law and harmonize national IP laws. So this webinar will provide a thorough analysis of the Swiss reports and the corresponding resolutions which were adopted at this AIPPI World Congress. Before starting, we have a few housekeeping rules, which are the following. So if anybody has any questions, the first thing is do not hesitate, please. Questions are most welcome. If you want to raise or ask questions, please do so via the Q&A box, which you will find at the bottom of your screen. There will be a short Q&A with each speaker after their presentation. If you encounter any technical problems during the webinar, please send a message in the chat box to AIPPI events. We have an AIPPI officer here online to help us with any technical problems. And there will be a brief survey after the webinar. Thank you for your feedback if you want to participate in that. We will have today 4 distinguished speakers, all from Switzerland. They actually all attended the annual Congress in Hangzhou last month. We will start with Lorena Piticco, then Manuel Bigler, then Fabian Wigger, and Joseph Schmitz. I will briefly introduce all speakers just before their presentations. So, let's start now with Lorena Piticco. So Lorena is a Swiss and European patent attorney and an European patent litigator with Isler and Pedrazzini Zurich. Lorena is specialized in molecular physics. After her admission as a European patent attorney in 2017 and her entry in the Swiss Patent Attorney Register in 2018, she obtained a diploma of patent litigation in Europe from the University of Strasbourg in 2019, which qualifies her to represent clients directly before the Unified Patent Court of the EU. Lorena became in 2023 a partner of Isler and Pedrazzini, and she will address today the resolution about harmonization of disclosure requirements and consequences of non-compliance, which was study question number Q289. Lorena, the floor is yours. Thank you very much.
Thank you. Now I hope that the sharing will work. So hoping that you can all see my screen, it's my pleasure to give you a brief overview on the background and the outcome of the study question Q209 that was directed to disclosure requirements and consequences of non-compliance in the field of patent law. So to begin with, I would like to give you a brief overview on the legal provisions so the Swiss group has identified with regard to requirements, disclosure requirements that we have in our patent law. So the first one relates to genetic resources and traditional knowledge. So we have an article in our patent law stating that a patent application must contain information on the source of either the genetic resource to which the inventor or the patent applicant had access, provided that the invention is directly based on this resource, or B, that the patent application must contain information on the source of traditional knowledge of indigenous or local communities of genetic resources, again, to which the inventor or the patent applicant had access, and provided the invention is directly based on this knowledge. So a second disclosure requirement we have identified in our law concerns divisional patent application, where we have a provision stating that the request regarding the grant of the patent, now for this divisional application, must comprise the number of the earlier application and the claimed filing date. And lastly, we have identified a provision that relates to the non-prejudicial disclosure, where our law says that if there has been an invention made available to the public 6 months prior to the application or priority date, then such a disclosure does not form part of the state of the art when it is due to or a consequence of a display of the invention by the patent applicant or his legal predecessor at an official or officially recognized international exhibition. So in this case, if the patent applicant files a declaration of immunity from exhibition with the request for the grant of the patent, and if that declaration fulfills the requirements in the sense that it designates the exhibition and it declares what has actually been shown there, then such a public disclosure does not form state of the art. So these were sort of like the only, let's say, the legal basis we have found with regard to disclosure requirements. And just to mention, unlike many other countries, we don't have any disclosure with regard to prior art, simply because of the reason that, at least for the time being, there are no examinations taking place on the merits, in the sense that the Swiss Patent Office does not examine a patent application with regard to novelty and inventive step. So having said so, let's move on to the report of our group. So there have been many questions, and I tried to group them sort of by means of their major topics. And one group of questions concerned whether or not, in our opinion, we think that our current law regarding the disclosure requirement is adequate and sufficient. And here our answer was quite simple, yes. So we do think that the requirements we have, the requirements on the source, on a parent application in the case of a divisional application, and a declaration of immunity in the case of a non-prejudicial disclosure is sufficient. We also think that the electronic exchange of prior art information we have nowadays between the patent offices, as well as any electronic file inspection, works quite well. So we are quite satisfied with the way things are. And we also think that patent applicants shall not be burdened with any additional administrative work that could relate to disclosure requirements, for instance, asking them to submit prior art from parallel proceedings as we know it from the US system, for instance. And we also think that applicants would suffer a legal uncertainty when they would have to decide whether or not a particular prior art document is relevant and needs to be cited. So a second group of questions concerned the actual content of a disclosure requirement. And here we have reached a conclusion that in our opinion, if there is a disclosure requirement, then it shall only relate to information relating to novelty and inventive step, and not, for instance, to a sufficiency or insufficiency of disclosure or plausibility and so on. And we were also of the opinion that the submission of the prior art as such should suffice, and that, for instance, it shall not be accompanied with any formal legal opinion that somebody or an office or a law shall require. And we also think that no translations shall be required. So for instance, if there is a prior art document in Chinese, then it shall suffice to submit that Chinese document, because nowadays we have machine translations available, so that there should be no burden for anybody to get a translation of a non-English document, for instance. And ultimately, we held that there shall be no binding admission in any later proceedings as to the relevance of the prior art. So with regard to the burden of disclosure, we were of the opinion that that burden shall bear the applicant and only the applicant. So for instance, not the inventor, not any assignees, licensees, or any other persons such as employees, so just the applicants. And with regard to any sanctions, we were of the opinion that if there is no information on a parent application, such as search results or so on, being submitted, then the legal consequence shall be a deemed withdrawal of the application of concern. And if there is no information on immunity from exhibition being provided, then that right shall simply be forfeited. And with regard to any sanctions of failure to provide information on genetic resources and traditional knowledge, we were of the opinion that it is fine the way the sanctions are right now, namely that there is a fine in that case, and we were of the opinion that there shall be no sort of interference with the existence or enforceability of the patent, so that these should be treated separately. Now, this brings me to the actual resolution. So I can say overall, the Swiss group was very happy with the outcome of the resolution. It quite well reflected the opinion of our group. And the resolution starts with some sort of a definition saying that, okay, the disclosure requirement disclosure is about relate to the disclosure of prior art to the patent office. And the resolution also concludes in stating that there could be or should be further studies regarding disclosure requirements that deal with genetic resources and traditional knowledge. So it's just about prior art, this resolution here. And the second point of that resolution is that there shall be no requirement for the applicant or any other person involved with the preparation or prosecution of the application, so for instance, the patent attorney, to disclose any prior art to the patent office. And that clause came into the resolution at a very early stage, so that we just don't want any disclosure requirement. And back then in China, we thought, okay, is this it? Are we done? Is it resolved? But then it has been decided to despite of this, we don't want any disclosure requirements to have additional clauses that shall further specify what we desire if there is, for instance, a disclosure requirement provided by the national law. So that's the reason why we have now here in our resolution additional points, although main point is there shall be no requirement. So a sub-point, let's say, is that there shall be no requirement for the applicant to search for prior art. And all patent offices shall share the information on prior art via a common database. So also here you can see that it very well reflects the opinion of the Swiss group that the offices shall deal with it at their end ultimately, because we have all the means available. So the second part of the resolution concerns with the case that if there is national law that provides for a disclosure requirement. And in that respect, the resolution holds that such disclosure requirement shall be limited to prior art cited by the patent offices for a same invention and only upon request by the patent office. And further, the resolution says that a submission of prior art alone shall satisfy the disclosure requirement, so that there shall be no need or requirement for an analysis or to make a reference to specific parts thereof. And with regard to a legal remedy in case of non-compliance, the resolution says that if it is discovered at any time after patent grant that there has been an intentional failure to comply with a disclosure requirement, then the relevant administrative or judicial body shall have the authority to partially revoke the patent, and only to the extent that the undisclosed prior art is detrimental to the validity of the patent claims. And lastly, the resolution states that any prior art information that is communicated to the patent office shall be made available to the public once the patent application is made available to the public. And lastly, the resolution holds that submitting prior art under the disclosure requirement should not be taken as any kind of an admission by the applicant, for instance, regarding the relevance of that prior art to any of the patent claims. So with that, I close my short presentation.
Thank you very much, Lorena. Do we have any questions from the audience regarding this presentation of both the resolution of the Swiss group and, I mean, the report of the Swiss group and the resolution of AIPPI International? Again, if you want to raise any questions, please do so using the Q&A box at the bottom of your screen. Okay, we'll see. I do have a few questions for you, Lorena. The first one is, I think that you mentioned this on your presentation, that AIPPI, it was resolved that AIPPI recommends further study of special disclosure requirements relating to genetic resources and traditional knowledge. My question is basically, why was this field, treated separately? What is the difference or the specificity of this?
So I would say that the problem or the difficulty is that although both relate to like prior art disclosure and a disclosure on such information relates to a disclosure, it is not related at all in a sense. So whenever we have a disclosure requirement, let's say in the daily life, in the life of a patent attorney, it really just concerns prior art that we are aware of and that submission. And that's something very different with regard to patents that are in the field of genetic resources and traditional knowledge, because the provision there is rather to have a transparency, for instance, to enhance a transparency and to sort of check that national requirements of the country of origins, that they are respected. So it's very like unrelated. And to find some sort of like a harmonization that deals with both of these aspects is quite different or difficult, or would like make it like very long. and ultimately, I guess, would still go back to having two separate resolutions on these separate topics.
Thank you. I see that we do actually have a question. I will read it aloud. So is my understanding correct that there was no discussion of disclosing prior art that should be exempted from the examination in the context of a grace period?
No, that wasn't a topic at the conference. So grace period is something that certain countries have or don't have. And if there is a grace period, then there are many national regulations that deal with what sort of qualifies and what doesn't. And that wasn't part of the present resolution.
Thank you very much. I do have another question, a very general question, but you mentioned that certain countries such as Switzerland do not have any disclosure requirements in Switzerland because we don't have any examination of the merits of the patent applications. What is the breakdown, to put it that way, worldwide of basically the countries which do have disclosure requirements and those who which do not have any disclosure requirements? So we have an idea, just globally.
So in other words, you asked me whether there, like, how many countries do an examination on the merits and how many do not. So unfortunately, I cannot really come up with like statistical numbers, but just from my personal experience, I quite often feel like Switzerland is rather exotic in that sense. Because if there are, let's say, technical rights that are not examined with, like, on the merits, then these are the utility models which certain countries have.
But which I find interesting is that, as you mentioned, the first clause basically at the outset of the resolution, the principle is that there should not be any disclosure requirement. So there was a consensus on that.
Very much, apart from the US that was strongly against it, but still I think Europe and also Australia that was very strong on that point were just like the majority. So that's how this clause came into the resolution by democracy.
Okay. Do we have any other questions from the audience or from the other co-speakers? Because if there are, that's now or never, basically. Okay, so if there are no further questions, thank you very much, Lorena. And we will switch to the other speaker, who is Manuel Bigler. So Manuel is an attorney at law, managing associate with Valdovis in Zurich. He works in the Valdovis Technology and IP group. He advises and represents clients in all aspects of IP law, with a particular focus on trademark, patent, and copyrights. His practice also includes unfair competition, media, and advertising law. And Manuel will address the resolution about trademarks entitled Conflicts Between Composite Trademarks, Including Non-Distinctive Elements. Manuel, the floor is yours.
Yeah, thank you very much, Thomas, for the kind introduction. Just to make sure, can you all see the presentation now? I see you nodding. Yeah, well, thanks very much for the kind introduction, and thank you for the opportunity to speak today about AIPPI's resolution 290, sorry, with the intriguing title, Conflicts Between Composite Trademarks, Including Non-Distinctive Elements. I will begin with a brief introduction to the subject of the study question. We will then look at what has been decided at the World Congress in Hangzhou and whether Swiss law is in line with it. And we will conclude with a brief glimpse at what was in the study guidelines and the study question, but did not make it into the resolution. First, before getting into the topic, I would like to thank my colleagues from AIPPI Switzerland who participated in this study question. It's been a real pleasure to work with you. And now let's get started. So determining similarity and likelihood of confusion between two trademarks is a key issue in trademark law. It is more difficult when one or both of the trademarks are composite trademarks, and even more challenging when they include non-distinctive elements. And this is where the study question comes in. It is about conflicts between composite trademarks, including non-distinctive elements. Let us break this down. So it's about conflicts, namely a likelihood of confusion between two trademarks, be that in registration or opposition proceedings or infringement proceedings. Then at least one of the conflicting trademark is a so-called composite trademark. It is a trademark that includes various elements, such as word elements, numbers, devices, colors, and so forth. And finally, at least one of the two conflicting trademarks is a composite trademark with a non-distinctive element. A non-distinctive element in general is an element that on its own does not act as a source identifier, such as a generic name, terms and images commonly used in trade, terms descriptive of the relevant goods and services, their characteristics, and so forth. For example, in the spirit of Thanksgiving today, let's assume that there is a trademark for a cranberry sauce called AIPPI Delight. In this composite trademark, AIPPI will be the distinctive element and Delight arguably the non-distinctive one. A conflict may now arise with the distinctive elements of another trademark, with the non-distinctive elements of another trademark, or between the distinctive elements of one trademark and the non-distinctive elements of another trademark. So for example, coming back to the AIPPI Delight cranberry sauce, there could be another cranberry sauce called Thomas Delight, and then we would have an overlap in the non-distinctive element Delight, or there could be a conflict with another trademark, AIPPI's Finest, which would then be an overlap in the distinctive elements of those two composite trademarks. So this is what the study question is about. What does it not cover? It does not deal with under which circumstances an element of a trademark is considered distinctive. It does not deal with when with rights preserving use, namely with whether, if you add a non-distinctive element to a registered trademark, that will still count as rights preserving use of the registered trademark. And it does not deal with grounds of infringement other than confusion, such as parasitism or dilution. Now, what has been resolved, and is Swiss law in line with it? Like this webinar usually includes a summary of the reports of the Swiss group and the corresponding resolutions that have been adopted in the World Congress. I have decided to do this by presenting you step by step, paragraph by paragraph, the resolution passed in Hangzhou, and then analyzing whether the Swiss law is in line with it. This will then also include a presentation of the Swiss report. The resolution is rather short. It has 5 paragraphs only. It begins by setting out a general rule of trademark law. It is necessary to look at the specific circumstances of each case, and this also applies where one or both of the conflicting trademarks are composite trademarks with a non-distinctive element. The assessment of similarity and likelihood of confusion should be made on a case-by-case basis. And this is exactly what paragraph 1 states. You've got it on the slide here. Now, what about Swiss law? The report of the Swiss group makes it clear that under Swiss law as well, similarity and likelihood of confusion are always assessed in the context of the overall circumstances of the individual case. And Swiss law, in my view, is therefore in line with the resolution in this regard. So we now know that the assessment is to be made on a case-by-case basis, but which rules or principles should guide us in this case-by-case assessment? And this is dealt with in the second paragraph of the resolution. The study guidelines identified 2 rules that are widely used when it comes to comparing trademarks. The first rule is the anti-dissection rule. According to this rule, trademarks are to be compared as an indivisible whole and not to be dissected into their individual parts. The second rule is the rule of the dominant element. According to this rule, the dominant element of a trademark is generally given more weight in the comparison of 2 trademarks. These 2 rules are not mutually exclusive, rather they can complement each other. Sorry, I already moved to the Swiss law, sorry for that. So they can complement each other, these 2 rules, meaning that the assessment is to be made on the basis of the overall impression left by the 2 trademarks, and that in this overall impression, the dominant element is given more weight. And AIPPI has just resolved that in paragraph 2 of the resolution. which states that in assessing similarity and likelihood of confusion between such trademarks, the overall impression of the composite trademark should be considered, taking into account the dominant element of either trademark, along with the distinctiveness of the elements and any other factors or circumstances relevant to the specific case. So we've got 4 aspects here. We have got at the very end the other factors and circumstances, which are addressed in further detail in paragraph 4 of the resolution. We will get back to that in a minute. And then we have the overall impression, the dominant element, and the distinctiveness of the elements. What the resolution does not say is how to decide which of the elements is the dominant one. I would argue that the visually dominant, the largest element, is not necessarily the dominant element, and rather the most distinctive element of a trademark will typically be its dominant element. Again, what about Switzerland? The Swiss group has set out in its study report that in Switzerland, the similarity of 2 trademarks is always determined by the overall impression made on the public. It's not permitted to break down, to dissect a trademark into different elements and then compare those elements. Furthermore, the public does not compare 2 trademarks simultaneously. Rather, we have to rely on the imperfect, somewhat blurred recollection of the consumers, and consumers will generally remember better distinctive elements of a trademark. It is therefore generally accepted in Switzerland that the more distinctive elements will normally have a stronger influence on the overall impression than the less distinctive elements. And there are, of course, other factors that play a role in the assessment of likelihood of confusion, and so therefore I believe that Swiss law in this regard as well is in line with the resolution. Another interesting question, here it is the role that a non-distinctive element may play in the overall assessment. This is addressed by paragraph 3 of the resolution, which states that a non-distinctive element of composite trademark should not, as a general rule, be disregarded completely when assessing similarity and likelihood of confusion, though said non-distinctive element would typically be given less weight in the assessment. And here again, the approach of Swiss law is very similar. Under Swiss law, non-distinctive elements may not be completely disregarded, as this would result in a mosaic-like view of a trademark, and this is not how trademarks are perceived or recalled by consumers. However, non-distinctive elements will normally be given less weight in the overall assessment, and so again, I believe that the approach under Swiss law is consistent with the resolution. Sorry, here is the Swiss law part. And you may now remember that according to paragraph 2, which we looked at before, there are also other factors and circumstances that can come into play. And those factors and circumstances are dealt with in paragraph 4 of the resolution, which sets out an open, non-exhaustive list of potentially relevant factors and circumstances, which may include, but are not limited to, the structure of the composite trademark, the perception of the relevant public, history and use status of the earlier trademark, and so forth. I will not read out the entire list here. And again, what about Swiss law? It would take too long to go through all those factors here, but the Swiss group believes in the study report that all of these factors can also play a role in assessing similarity and likelihood of confusion under Swiss law. So again, in my view, Swiss law is in line with the resolution here as well. And the last paragraph of the resolution now addresses whether this approach that has been adopted by the resolution should govern in registration proceedings, including opposition proceedings, as well as infringement proceedings. And the resolution says that this should be the case. Again, under Swiss law, it's in line with this. It's generally accepted that the comparison between 2 composite trademarks should be the same in registration and opposition proceedings, as well as in infringement proceedings. So to conclude, AIPPI's resolution sets out certain cornerstones of how to deal with conflicts between composite trademarks, including non-distinctive elements, and the approach adopted under current Swiss law is already in line with the resolution. I would like to now devote the remaining time, if that works, to what is not in the resolution, but was part of the study question. In my view, that's almost the more interesting part of the study question. As you surely have noticed, the resolution is rather high level and leaves a lot of room for interpretation. It gives us a set of rules that should apply in such conflicts, but it does not say what the outcome of these conflicts should be. And in this regard, it's noteworthy that the study guidelines presented the national groups with several scenarios that one can often find in practice. They ask how the national groups deal with these scenarios under current law and what they believe under a harmonious approach should be the proper way of dealing with them. As I mentioned, this has not made it into the resolution, but I believe that it will nevertheless be interesting to share with you. So we've got a first scenario. Here we've got on the left a senior trademark. And then on the right, we've got a junior trademark that consists of the senior trademark or a sign similar to the senior trademark and some non-distinctive elements. Under Swiss law, as set out in the study report, adding a non-distinctive element to a senior trademark will usually not result in a different overall impression, so that the two trademarks in this scenario are usually considered similar. Exceptions may apply where the senior trademark is merged with other elements in such a way that this results in a different overall impression. But as I mentioned, that's rather the exception than the rule. Of the national groups that answered the policy question whether these two trademarks should be considered similar, about half thought that the trademark should always be found similar. A further quarter or so, including the Swiss group, thought that they should be found similar in all but exceptional circumstances. So I think in general, merely adding a non-distinctive element to a pre-existing trademark should in general not avoid a likelihood of confusion. And that's the case in registration proceedings as well as in infringement proceedings. The second scenario in the study guidelines, in this scenario, we have a senior trademark that consists of both distinctive and non-distinctive elements. And we have a junior trademark that consists only of the identical distinctive elements as the senior trademark. Under Swiss law, if junior trademarks takes over the distinctive but not the non-distinctive elements of another senior trademark, the overall impression of the trademarks will typically remain the same, so that the trademarks are considered similar. Again, this view was shared by most of the national groups, with most groups answering that the trademarks in this scenario should always or almost always be considered similar. Hence, taking over distinctive elements of a pre-existing trademark without adding further distinctive elements should in general result in a likelihood of confusion. And in the third scenario, we're now talking about taking over non-distinctive elements. Here we have got a senior trademark on the one hand that consists of distinctive and non-distinctive elements, and a junior trademark with different distinctive elements, but the identical or similar non-distinctive elements. Under Swiss law, the study report sets out that identical or similar non-distinctive elements with different distinctive elements will in general not suffice for two trademarks to be found similar. In my view, this is also appropriate because the exclusive rights conferred by a trademark should not extend to non-distinctive elements. And again, this view was shared by most of the national groups. Therefore, in my view, overlapping non-distinctive elements should in general not suffice to lead to a likelihood of confusion. This concludes my presentation. Thank you very much for your attention, and I'm happy to hear your questions, if any.
Thank you very much, Manuel.
We'll stop sharing this then, right?
You can.
Okay.
Very good. So awaiting any questions from the audience. Do not hesitate. Well, I will start with one question on my own.
One, yeah.
Sure. I understand from your presentation and the resolution and basically the comparison between the resolution and Swiss law that there was common grounds to adopt the resolution, but to your recollection, was there any controversial question during the debates before the AIPPI assembly, or was it a straightforward resolution from the outset?
It was a very straightforward resolution from the outset. the study committee meeting didn't take too long because it was really not controversial. It was a lot of wordsmithing, in my view, whether you add a word here or there, but what has been proposed by the study committee leadership has basically been adopted in the end. Maybe the resolution wasn't overly ambitious. Maybe we could have, you could have included the scenarios that I presented at the very end, and to try to find some common ground there as well, because I believe, that most of the national groups that answered those questions shared the same or a similar view. Yeah, but it was not a hugely controversial resolution.
Okay, so it means that the laws of different countries are already basically harmonized on this subject.
I wouldn't say so. I think because the resolution leaves a lot of room for interpretation. It's rather vague and high level. So a lot of laws will find themselves to be consistent with the resolution. But in practice, what we often see when you have conflicts between composite trademarks, that one country decides it in one way and another country in another way, even though, on a very high level, we might have the same approach that is adopted. Again, I think that's due to the high-level nature of the resolution, and because we didn't go into details of how to deal with those conflicts in practice.
Okay. Well, thank you very much. Are there any other questions from the audience or from the co-speakers? If this is not the case, thank you again, Manuel, and we will now move forward to the third speaker. So our third distinguished speaker is Fabian Wigger. Fabian is an attorney at law with Weinmann Zimmerli in Zurich. Fabian advises and represents national and international clients in all aspects of IP law, with a particular focus on copyright law. And Fabian lectures on copyright law at the University of Zurich and the University of Applied Sciences in Winterthur. And he became a partner at Weinmann Zimmerli in 2022. So Fabian will present the resolution on copyright entitled Defense of Parody in Copyrights. Fabian, the floor is yours. Thank you.
Thank you, Thomas. Yes, as you said, this year's copyright study question was dedicated to parodies. In my view, an exciting topic, especially because the respective cases are often colorful and often attract interest beyond the copyright community. I'll give you a few examples to warm you up for the topic. In the 90s, a hip-hop combo adopted Roy Orbison's well-known hit, Pretty Woman, in a hip-hop style. And as you can imagine, the picture of the pretty women were quite stereotyped in a very hip-hop way. So Roy Orbison didn't like that, and he went to court, but the US Supreme Court found in a 1994 leading case that this could be a parody for which the consent of Roy Orbison is not required. But you don't have to go to the US. I'm having a problem to find parody cases. Recently, a single judge at the District Court of Zurich ruled that songs from a musical called Drittligasse may be changed and updated without the right holder's prior approval. And parodies are not only something that are relevant in the musical sector. Here, another example, more from the visual arts. An example from the European Union, where the European Court of Justice instructed a Belgian court on how to examine a parody in the following setup. A right-wing party used the cover of a satirical magazine, pictured on the left, for a calendar, pictured on the right. And they did not take the picture as it is, but they changed some things. They changed the main character to look like the mayor of the city of Ghent, which spends, or better wastes, money to people. And these peoples can easily be identified as Muslims. And of course, the author of the original work did not like that Islamophobic adaptation and went to court. So there was a discussion whether this could constitute a parody. And all these cases have in common that the underlying question is, can you make such kind of adaptations without having to ask the author or the right holder of the underlying work? And this was also the main question underlying Q291 that we dealt with. I was part of the Swiss country group that worked on this copyright question, a fantastic group. We prepared a report that summarizes the situation in Switzerland and our findings regarding a potential harmonization on this issue. If you're interested, check out the latest issue of the SIG journal. Along with us, 42 other country groups have also submitted their reports to the International Committee. And based on these country reports, a summary report has been prepared, which should be available on the website of AIPPI International. So let's dive into the resolution that has been adopted at the Hangzhou Congress. I will go through the resolution step by step, and I will, for every paragraph, also make some comments on whether what is required or requested by the resolution is already fulfilled under the legal situation in Switzerland, or whether there's some need to change or adapt the practice regarding parodies in Switzerland. Paragraph 1 says that parody should be recognized as an exception under copyright law. So this is not really surprising on the one hand. If this would not be the case, the resolution would be rather short. I would be able to end here. On the other hand, it is not surprising because the vast majority of countries that participated in the survey, they already have some kind of exception or limitation or defense addressing situations like parody or the like. Also, Switzerland has an exception for parody. It's in the Copyright Act itself, in Article 11, Paragraph 3. So we are already compliant with the resolution in that respect. Paragraph 1 of the resolution states that parody is a form of freedom of expression. So this is insofar interesting as the fundamental right of the freedom of expression is actually what justifies the parody exceptions. The parody exceptions are here to balance the interest between the right holders and the authors, their interest in having strong copyrights, and the interest of third parties that want to use existing works to make some kind of expression, to make some kind of comments on something, and they are in that respect covered by the fundamental right of freedom of expression. This is also the common understanding of the justification of the parody exception under Swiss law. Also, paragraph 3, no problem for the legal situation in Switzerland. Also in Switzerland, it's clear that you can use any type of work for making a parody. So it's not limited to musical work or to works of visual arts. You can even make parodies of software code if you're able to do so. Now I'm quickly moving forward to paragraph 8 of the resolution, as I want to take that issue somehow before the bracket, before we go into more into the details. This paragraph 8 says that when assessing whether a specific alteration of a work qualifies as a parody, you should do that assessment along objective criteria. You should not look at the intent of the parodist. You should look at the parody itself. I think that's compliant with the legal situation in Switzerland. I make a little question mark here because we just don't have any case law specifically stating that. But if you look, for example, on how the Swiss Federal Tribunal wants you to assess the requirement of individual character of a work, it stresses very much that you have to make an assessment on objective criteria, and you do not have to look at the intention behind such a creation. So I think we're compliant on that respect. Paragraph 4 of the resolution now deals with the specific criteria that have to be looked at when making such an objective assessment. So, number 1, the parody must be recognizably different from the underlying work. Quite clear. If you just take a work, do not change it, this cannot be a parody. This is also clear on the Swiss law, and it's already clear just from the fact that the Swiss legislature included the parody exception in the article dealing with the integrity right of the author. So only alteration of an existing work triggers the parody exception. If you do not change anything, you cannot rely on the parody exception. Number 2, very important, reflecting that the parody exception is here to serve the freedom of expression. So you have to alter the underlying work, but you have to alter it in a way that you add something new to it, an element of humor or mockery, or an element of critique. It does not matter whether the critique targets the underlying work or its author or something completely different, but you must add some of these additional elements to be able to benefit from the parody exception. That's also the common understanding in Switzerland. Now, in my view, the most interesting and the most difficult aspect to be considered when assessing whether an alteration of a work qualifies as a parody or not. It's that the parody or its exploitation must satisfy the 3-step tests reflected in the Berne Convention and TRIPS, or in the World Copyright Treaty. As Switzerland is a member state of these treaties, of course, this requirement applies also on the Swiss law. But what does it mean? Here are the 3 steps underlying the 3-step tests. Step 1 is not that problematic in this respect. It just says that exceptions on the copyright law, they must be limited to certain specific cases. So you can just say that parodies is a certain specific case, so that's fine. Step 1 is not the interesting part, but it gets more interesting if you go to step 2. It says that what is uses that are falling under exceptions, they may not conflict with the normal exploitation of a work. Meaning, in the case of parodies, that if the exploitation of a parody conflicts with the normal exploitation of a work, you will not be able to rely on the parody exception. Now the question is, what is the normal exploitation of a work? I mean, particularly in the field of musical works, where the rights are typically administered by collecting societies, which cover a very, very broad field of exploitation. I think you are quite fast in a sector where you conflict with the normal exploitation of work. So this is really an element that might narrow down the scope of application of a parody exception. Step 3 of the 3-step test actually reiterates that it's about a balance of interest, about the interests of the author and the right holder and the interest of the beneficiaries of an exception. I will come back to that steps at a later point. Moving forward, in paragraph 4 of the resolution containing the different elements to be considered, number 4 says that a parody must not be protected itself under copyright law. It must not satisfy the minimum level of originality to be protected. This requirement has been discussed in Switzerland as well. You can find legal literature that states it must satisfy the level of originality. You can also read scholars that state the opposite. In my view, it's not that important because it's hardly possible to imagine a parody that fulfills all the other criteria, but not the level required to attain copyright protection. Point 5 states that the exception for parodies is something different, like the exception for citation, for example. You don't have to mention who is the original author or where you have found the original work. You don't have to identify the source. So there's absolutely no attribution requirement. This is also the common understanding on the Swiss law. Point 6. It's clear that you don't have to ask for permission from the original author. If you would have to, maybe the exception would make no sense at all. And in principle, you also do not have to pay a remuneration to the right holders of the underlying work. But I think there might be cases where paying a remuneration might help you to take the 3rd step of the 3-step tests, so that the weighing of interest may be more in favor of the parodies if he just pays at least the remuneration that is typically owed for such kind of uses to a collecting society, for example, in musical works. So that might help him to overcome the 3-step test requirement. But as a general rule, you don't have to pay. That's also actually the understanding in Switzerland, although there's no clear case law in that respect. Last but not least, you may not mislead the public as to the nature or the author of a parody. So it must be clear to the public that this is something else than the original work. This is an adaptation, and it must be clear for the public that this is the case. Otherwise, the public would not be able to receive the message that is actually protected by the freedom of expression. That's also the understanding on the Swiss law. Commercial exploitation of a parody is not per se a problem, but coming back to the 3-step tests, such a commercial exploitation might in specific cases interfere with the normal exploitation of the underlying work, and then you have a problem on that front. So not per se a problem. That's why it's also written like that in the resolution. But if you look at the 3-step test, this might become an issue. I would say that's also the case on the Swiss law. Well, it's clear that making a parody is connected with making alterations to a work, and this typically triggers moral rights of the author of the underlying work. So that's normal. That's not something that prevents the application of a parody exception. On the other hand, the parody exception is not here to justify a distortion or mutilation of the underlying work. It's not here to justify an infringement of the personality rights of the author of the underlying work. So that's also the common understanding in Switzerland. You even have the provision in the copyright code itself that a parody may not lead to a Entstellung, meaning an alteration infringing the author's personality rights. Okay, that's the resolution. As you see, it definitely provides some guidelines for assessing parody cases that could also serve as a basis for discussions under Swiss law. Nevertheless, even with these guidelines, it is likely that in specific cases, different lawyers would come to different results. So ultimately, many appraisals of circumstances and interests are needed in these matters, and they cannot be easily standardized, even with that nice resolution. Well, but maybe the question whether a specific type of use constitutes a parody or not will soon no longer be that interesting, because the question whether something is a parody or not might soon be overtaken by something else. Let me close my presentation to make a short outlook on that issue. If you look at the provisions dealing with parody exceptions, you see that they typically do not only deal with parodies, but they also deal with comparable adaptations. That's the case in Switzerland, and in the European provisions, you typically have parodies besides caricatures and pastiches. Now, what actually are pastiches? In my view, nobody really knows. Courts in Germany tend to interpret that term in a very broad sense, so that it covers inter alia the sampling of excerpts of pre-existing musical works. So that came into application in the big cases Metall auf Metall, where it's about sampling. And maybe the German Supreme Court is not that comfortable with that broad interpretation of the term pastiche, and it wants some clarity on that question. So it has referred some questions to the European Court of Justice. And as you can see here, the German Supreme Court wants to know whether pastiche can really be understood as some kind of catch-all clause for all types of artistic transformative uses of a work, including, for example, samplings. And the German court also wants to know from the European Court of Justice what kind of criteria should be applicable in that respect. The judgment of the European Court of Justice in that case is to be expected in the course of the next year. Depending on the outcome, it may well be that pastiches are going to be the much more powerful tool than parodies to privilege very different types of transformative uses. So with that outlook, I have come to an end of my presentation, and I am, of course, available for any type of questions you may have.
Thank you very much, Fabian, for this very interesting and exhaustive presentation. We do have 1 minute for a question, either from the audience or from elsewhere or somebody else. Do we have any questions from the audience? I don't see any. I think, Fabian, that we will now directly move on to the next presentation because it's 6:05 already. So again, thank you very much, Fabian, for this very interesting presentation.
Thank you.
We're coming now to the last speaker, who is Joseph Schmitz. Joseph is a Swiss and European patent attorney with Isler and Pedrazzini in Zurich. Joseph studied molecular biology and biophysics at the ETH in Zurich, and he has a particular experience in obtaining and enforcing supplementary protection certificates. Joseph completed the diploma patent litigation in Europe at the University of Strasbourg, which entitles him to represent clients before the Unified Patent Court of the EU. And Joseph became a partner at Isler and Pedrazzini in 2023. Joseph will talk about the resolution entitled Unjustified Allegations of Infringement of IP Rights. So Joseph, the floor is yours. Thank you. You are muted, Joseph.
I realize right now. Thank you. Thank you, Thomas, for the very nice introduction. As you said, I will be talking about the Q292 question and the ensuing resolution that was taken at the AIPPI World Congress. Of course, at the basis of all of this is the Swiss National Group, which I had the privilege of being a part of, and I wish to thank my fellow members of the group, in particular Lara Dorigo, the chair, Theo Choi, Philippe Gros, Peter Ling, Martin Toletti, Raphael Singh, all of whom are accomplished legal practitioners. So the title was Harmonization of Unjustified Allegations of Infringement of IP Rights. And I think it bears to explain what exactly, or what more or less was understood to be an unjustified allegation. So this is from the adopted resolution, the background section, where it is explained what this resolution is about. And it does state that unjustified allegations of IP infringement in particular are the kind of activities that constitute unjustified allegations of IP infringement, and B, consequences of making such unjustified allegations of IP infringement. So what are those and what are the consequences thereof? And the resolution specifies that a unjustified allegation of IP infringement refers to infringement allegations that exceed the boundaries for the legitimate exercise of an IP right. So it sounds very nice, but I'm not sure if it means a lot. And the resolution also pointed out that it doesn't want to focus on competition law aspects or antitrust law aspects that are connected with the allegations of IP infringement. So now moving to the Swiss report. The Swiss report isn't yet available. It is submitted and it should be available in the SIG magazine edition of December. But right now it's not yet published as far as I know. What follows is, of course, a rather compressed view of what was contained in the report, but still, I wanted to point out several aspects about the Swiss perspective that was submitted. The AIPPI requested the Swiss National Group to provide information about several things. First and foremost, of course, is this a thing in Switzerland? So the Swiss group was asked to provide information on whether the Swiss law distinguishes between justified and unjustified allegations of IP infringement, which, as far as the group was concerned, it does not. There is no legal provision that deals with justified or unjustified allegations of IP infringement. Furthermore, IPPI wanted to inquire about criteria that could be considered when assessing justified or unjustified allegations of IP infringement. And while there was no provision in the law, upon close study of the jurisprudence, the Swiss group was able to point out that several decisions under Swiss law provided criteria that could be applied to determine whether an allegation was unjustified. The first was having doubts about the validity of the IP right that you are assessing. So if you must know that your IP right is somehow invalid, that can constitute a criteria for later stating that your allegation of IP infringement was indeed unjustified. Also, bad faith, of course, was one of the factors. If you do something of which you have to know that was bad, this can also result in a finding of an unjustified allegation of IP infringement. And finally, if you are, of course, careless or negligent, if you did not ask your attorney at law or patent attorney about the consequences of your action when making an allegation of IP infringement or the meaning of your claims in a patent, that is also grounds for finding that a certain allegation that you made at the time was indeed unjustified. Furthermore, the Swiss group provided information as to the remedies that could be sought by a party that was affected by such an unjust allegation, and found that, of course, declaratory judgments can be sought if one suffers an unjustified allegation. And moreover, once the decisions are rendered, the party that has suffered an unjust allegation may have the decision published in a newspaper, or may even have the judgment sent to parties that were affected by the decision or were affected by the unjust allegation of IP infringement directly. And lastly, of course, there is the possibility to seek damages after having suffered an unjust allegation, if indeed you can connect the damage to the unjust nature of the allegation. And finally, also, well, this being an IPPI matter, of course, the Swiss group was asked to provide input about improvements in Swiss national law and also in harmonization efforts. But the Swiss group was of the opinion that the Swiss law didn't need improvement as pertains to this particular subject, because there was apparently adequate legal framework to deal with matters of unjustified allegations of IP right, and that it was functioning more or less the way one would expect. And surprisingly, or maybe unsurprisingly, all the legal practitioners were of the opinion that harmonization was not desirable in this particular field, because it would be a very, very ambitious undertaking, since a lot of legal traditions and legal systems coexist on a global level, and bringing them together on such a topic was very ambitious indeed. And perhaps also because the more complicated the system is, the better it is for attorneys, of course. But that wasn't in the report. So turning now to the actual resolution as it was adopted at the World Congress in Hangzhou, after some debate, I can report that the resolution contains, unsurprisingly again, a passage that there should be harmonization, which is, of course, after having presented the Swiss position that there should not be harmonization, it's almost funny that the resolution now says there should be harmonization, but of course this is AIPPI and it's one of the goals of the association. So the resolution starts off by stating that the determination of whether an allegation of IP infringement is unjustified should be, of course, a fact-sensitive approach which combines objective and subjective criteria, such as the motivation of the party making an allegation of infringement, the knowledge of the party regarding the validity of the IP right that the party is assessing, and of course, whether there was a reasonable assessment beforehand about the possibility of infringement of the IP right that is being enforced. So far, this kind of correlates with the Swiss approach or with what the Swiss group communicated to the AIPPI. Furthermore, and this is interesting, the resolution contains two passages where it is said that the mere fact that an allegation of IP infringement is later proved incorrect, either because the IP right was not valid or because the IP right was not infringed, does not in itself conclusively warrant a finding that said allegation was unjustified. And on the opposite side, it equally stated in the following passage that the mere fact that an allegation of IP infringement is later proved to be founded, for example, by a decision on the merits by a court, does not also in itself conclusively warrant a finding that the allegation of IP infringement was justified. So this is very nice and might be summarized by "it depends." And there wasn't much discussion about these paragraphs, I might add. So this one sailed through really nicely, actually. Further on, it was discussed whether some circumstances should be excluded as leading to a finding that the allegation of IP infringement is unjustified. And one of those was that, well, making an allegation of IP infringement when the party making the allegation knew or should have known that the infringement claim had a low likelihood of succeeding, which is of course trivial in a sense, because if only courts or if parties would only bring forward cases with a very high likelihood of succeeding, I wonder if anyone would be brought. And then also making an allegation of IP infringement before the IP right has been granted, provided that such communications does not assert the IP as granted. So making a claim that you are infringing my IP right while knowing that it is not yet granted, that you still have not gotten that IP right. Or making an allegation of IP infringement when settlement negotiation or other dispute resolution processes are going. So this goes into, well, you could say that's bad faith, but yeah, these are the things that were found to be not as red flags when dealing with allegations of unjust infringement. And finally, and this is, I think, important for the whole profession, is that we are not on the hook on this. IP or legal professionals, it was decided, acting in their professional capacity and in accordance with, of course, applicable professional rules of conduct on behalf of their clients, shall not be personally liable for making unjustified allegations. So everybody was relieved that this was passed. And then, of course, Other things were also, this is of course compressed, but and you can read up on it if you want it in more detail. But it suffices to say that also the burden of proof matter was discussed, and I think it's natural that the burden of proof should rest with the party to whom the presumably unjustified allegation of IP infringement was made, meaning that, well, this is just as in civil proceedings, I guess, everywhere in the world. And then finally, IPPI also held in the resolution that remedies should be available to those parties who suffered unjust allegations. And there was a very long, well, there was a quite long list that was provided in the resolution, but as you can already imagine, some remedies were available under some jurisdictions, like common law jurisdictions, while others didn't provide these legal remedies. So it was a quite long list, and I think no remedy was forgotten. And it was finally, I think one could say that this resolution passed really easily. There were some amendments, but ultimately it was a quick work during the plenary session where the resolution was adopted. And with this, I believe I am at the end of this presentation, and thank you for your attention.
Thank you very much, Joseph, for your presentation. Do we have any questions from the audience? Doesn't seem that there are any for the time being. Joseph, I do have one question for you.
Sure.
You mentioned, the main factors under the Swiss jurisprudence for assessing whether one party has made an unjustified allegation. I understand that these factors are, for instance, serious doubts about the validity of the IP rights, bad faith, and being careless or negligent. These are obviously all subjective factors. Are there any objective factors to be taken into consideration in this context?
Well, I think I could not tell you what objective factors were extensively discussed during all the deliberations that we had. It was really most of the discussion, unfortunately or fortunately, focused on the subjective part of the matter, whether somebody should have known about something, whether somebody should have taken due care in assessing these things.
Okay, thank you. I find that quite interesting because in the in your slides you mentioned, for instance, that
I know in the beginning it says a mixture of subjective and objective characteristics, but
the example was also that you can make an unjustified allegation even if at the end a court of law decides that your allegation was justified. But if you were making this allegation in bad faith, for instance, or thinking that your allegation could be unjustified, that's enough. That is sufficient to conclude that the allegation was unjustified, even if it was objectively and eventually found justified or objectively correct.
Yes. The word objective, the only instance of the word objective is in the passage I presented. So it wasn't discussed much, but it's true. But as always, you always have a very hard time proving bad faith. Catching somebody with their hands in the cookie jar is usually quite a hard thing to do.
I agree. Okay. If we don't have any further questions, I think that I can thank you once again, Joseph, and seize the opportunity to thank all our 4 distinguished speakers of today. Elsa, do you want to display the last slide just for me to say a few words about the activities of AIPPI International? So just a few words about upcoming webinars. Artificial Intelligence in IP from Patenting to Infringement, and AIPPI Germany Young Members webinar, which will take place on 9 December 2024. So further information will be communicated by AIPPI, so watch out on that. And there's the midterm meeting in February in Zagreb, Croatia, about AIPPI International. Early bird registrations are open until 10 January 2025. And maybe as last words, for those of you participants who are not yet members of AIPPI Switzerland or AIPPI International, do not hesitate to register. Thank you very much again to our 4 speakers. Thank you very much to Elsa from AIPPI International for organizing this webinar. And thank you very much to you, dear participants, for having attended the webinar. Thank you and goodbye.